Street Bank and Trust versus the Attorney General.
Thanks.
Mr. Durland.
Good morning. Good morning, Chief Justice and Justice of the Court. Sanford Durland and I represent U.S. Trust Company, successor trustee to State Street Bank and Trust Company of a trust that was created in 1950. And I'm here today, I believe, on a very discrete issue on direct appellate review. In the trial court, the Internal Revenue Service was defaulted, but I'm here today to seek a binding decision on the IRS under the holding and commissioner versus estate of Bosch. Now, the trust, as I said, established 56 years ago, sought to provide scholarships to students of the graduating students of the Plymouth High School. And over the years, the trust had been reformed to both address the population shifts in the town of Plymouth and the creation of various high schools, the merger of Plymouth High School with the town of Carver's High School, the subsequent, I think, change in the price of higher education and the increased benefits that the trust might provide. The last reformation was in 1988 and provided that the scholarship amount could be between 5% and not greater than 10%.
That's a real question, though, is how you interpret that, strikes me. That reformation in 1988 struck the entire third clause, right?
And replaced it, yes.
And in the third clause, the original third clause, was there a specific amount limit on the amount of a scholarship?
Initially $200 and then amended 2 years after and prior to the donor's death to $400.
And then that was completely stricken and replaced by this. So why wouldn't you read this to suggest that each scholarship could be at least 5% and not more than 10%? I
think that is in fact a fair reading, and I think that is what it now provides.
Well, then why is there a sense that scholarships are limited to $400? They're not limited to $400.
They're not, no, and I didn't mean to create that impression if I have.
But they are limited to 5 or 10%
of the net income.
Of the net income.
Right.
In other words, the trustees sit down and say, okay, we got these many students this year, let's give 10%. Mm-hmm. So everybody gets the same amount rounded to the nearest 100.
Correct.
Yeah.
But that's the point is 10%.
100 of those, couldn't you?
Well, you could, Your Honor, and in fact, you could exhaust the net income created by the trust,
right.
Which I think my
But
brief
he wants
indicated.
it in perpetuity, didn't he?
Correct, but there's two issues related to Justice Marshall's question, and that is they don't give out 100 scholarships. The trust itself has various criteria that the scholarship committee looks at. And based on that criteria, there have been a limited number of scholarships issued every year, number one. And number two.
Because, I mean, the criteria as I read them seem to be fairly broad.
They are broad. I mean, it's things like scholarship and integrity and character and the like. And that is very broad.
But if the trustees are determining that there are not sufficient people to qualify such that you have excess income for federal taxation permit, there shouldn't be a trust reformation, because it's not as if the trustees have come in to say in any given year we cannot find more than 4 people.
Correct.
4 graduating seniors. I mean, can the trustees not decide to give to 20 graduating seniors?
Well, they're not limited in that respect. I mean, they certainly
No, I understand. But with this, looking at integrity, are you telling me there are only 4 graduating seniors or 5, from a given class who have integrity? Is there an and? I didn't remember there was an and in what you have to show.
Well, I think the need for the reformation is really related to Section 4942 of the Internal Revenue Code.
Right.
I think that's the driving force here.
Right. No, I understand.
And there, the trustees are struggling with, well, I mean, let me step back and say, parenthetically, there's another, I mean, now Plymouth has since changed.
That's a different...
That's a separate
so
issue.
Let's leave that aside.
Leave that
Let's just
aside.
deal with
The issue,
money.
the code issue, 4942,
Right.
limits the trustees.
In what way?
In the sense that to avoid
Federal...
a federal tax of 15% on the undistributed
income.
net income, the code talks about a 5% minimum investment, and that equals assets. 5% of the net minimum investment assets ought to be distributed to avoid the tax.
Correct.
Right now, even if all of the annual net income from the trust were to be distributed to whatever number of scholarship recipients the scholarship committee deemed appropriate, that still would not satisfy 4942.
Why? I mean, when I ran the numbers, it seemed to me that unless the trustees thought they were limited to $400, which you've now said they are not.
They are not, no. The number would be slightly higher based on the investment return right now of 5 to 10% on $13,000 annual return. It's $600 to $1,300 a year.
I
Yeah,
always
so
thought...
you give $1,300, and how many scholarships do you have to give before you begin to bump up against the 5%?
Well, you're limited to the net income versus the 5% of the net assets under Section 4942, and there's the
I see,
distinction.
I see.
Income versus assets. And even if you, I suggest, Your Honor, even if you exhausted all of the net income,
I see. I'm with you.
regardless of the number of scholarships,
I'm
you
with
would bump up against the tax on the net investment
Thank you.
assets. And that number is roughly triple under current numbers, under current trust assets. It's roughly triple the net income amount.
I'm with you.
Okay?
So it's
So the
five-
net income amount is actually quite low.
It is.
13,000.
My brief references at the time was around 13,000. It's invested in very low return bonds and whatnot. So it's not generating a lot of income at all. And that might change, but that's
So you could make a revision if we decided to go in your way that said in substance, they could do whatever's necessary to meet 4942.
That's essentially what
and
my
no
li-
more. And
Yes.
no more.
In fact, what the proposal that I put in my brief is the greater of the net income or the minimum investment return.
But here's the problem with that, which is that if you, in fact, continue to have to pay this 15% federal tax on the undistributed amount below 5%, that's 15% of whatever that amount is. If you distribute, however, all the way up to 5% under the current income stream, won't you be depleting the principal at a dramatically fast rate? And isn't that one of the things that the benefactors clearly didn't want to happen?
Well, that's certainly a possibility, Justice Court. I mean, that possibility does exist, given the current investment structure. And I think the trustees would then, again, I think they would take steps to change the investment or portfolio of the trust, which for the past 50 years they haven't had to do.
It's making a lousy rate of return, isn't it?
Well, it's a very low rate return, I think, again.
Like 2%?
It's based, I think
Well,
it's...
why don't, if the investment strategy changed so that you maximize your return, which you can then distribute, correct?
Correct.
I take it that you are placing the principal at greater risk, correct?
Right now, you would be. If reformation occurred and to comply with 4942, you would. That is
How much is the tax under 4942?
15% on the
assets.
undistributed amount of net income generated annually.
15% of undistributed?
Undistributed income, yes.
Well, that's not much, is it?
It isn't much, but...
I mean, suppose it's $13,000 hypothetically, or $14,000, and they give, 10 scholarships of $1,300 each.
Right.
Then they're left with what? $1,000, and that's taxed at 15%. That's $150.
Yes.
No, that wouldn't be
But
right.
you-
The amount it's taxed on is not just the undistributed net income,
It's the
but the
assets.
difference.
It's the difference, that's right.
The difference
It's the difference.
between
Correct.
5%, which is the imputed net income.
Correct.
And how much you actually distribute.
That's correct.
So it's
So it would be a lot more than
It's
that.
4942, which is.
That's
but
the point. I mean,
the
and again-
difficulty for the court is, what is clear, it seems to me, that this testator wanted this to continue into perpetuity. if you don't change your investment strategy, right, and if the court permits a reformation that permits the trustees to distribute whatever the difference is for under 4942, then you are eating into principle, as Justice Cordy said, at a huge rate. And we can't tell the trustees, oh, no, what you've got to do is adopt a less conservative investment strategy so that it bumps up, so that, in fact, the spread between the income tax on the income and the tax on the 5%, the failure to distribute 5% of the assets is smaller, so that you in fact keep your principal.
Well, I think the trustee would, I think, obviously, it would take a different tact based on its own obligations, as its own fiduciary obligations. I can also say again, and it's an aside.
But wait a minute. Think about the fiduciary obligations. Now there's a trust instrument that says you can distribute up to 5% of the assets, because that's effectively what it becomes. The fiduciary is not obliged to adopt a higher risk strategy in order to minimize that. Is the fiduciary?
No.
Well, no, I don't think so.
I don't think so.
But even using 4942, the tax, the calculation ratio that was just mentioned, the tax is still pretty small. It's about $1,000 if I do my math right.
Well, no, it is. I think it's fair to say that it is not a remarkably large sum. I mean, there's no question about that, regardless of the calculations. I mean, depending on how it's interpreted. But I think, while 4942 brings me here today, I think what needs to also be considered, at least as part of the picture, is that the trustee is also seeking to address the practicality of now two high schools and the general cost of higher education as a whole, as it has evolved over the years.
That's been done in the past simply by upping the amount. So I understand, and in fact, of course, it's evolved. But if you have a percentage, I mean, one could come in and say, I would like a higher percentage so that you have fewer students or whatever. I mean, you can give, but that seems to me to be a different claim than what you're making here.
Yeah, but here you really can't up the amount because, unless, of course, we adopt what you want, right? Because you're stuck with 5 or 10%, or between 5 and 10%.
Right.
But at the present time,
that's per scholarship.
Per
That is
scholarship.
per scholarship. So
Per
you
scholarship.
absolutely could distribute 100% of your net income.
No,
10
but
scholarships at 10%.
But you could get
That's
a
right.
you could have applied for the functionally equivalent of a 1988 amendment that says it's got to be, between 25 and 50%, so that you get more money to the students, at least for the net income piece.
Yeah.
You can get more money to the students, to fewer students, which appears to be consistent with what the donor wanted, namely that there would be a few students who would be selected as particularly worthy. And one way to accomplish that, which is consistent with prior reformations, one of which the donor signed on to, was that you bump the amount up. And you don't come in with a dollar amount, you just bump the percentage up.
But I suggest that the suggested language that I've put in my brief does, in fact, address that.
No,
Yeah,
it does, but it takes care of another problem.
Based on what you guys want, you conceivably could give all of the money to one student.
Correct. Correct.
Could I ask you this about the high schools? I have two questions. One, under your proposed language, why would a trustee in 30 years' time, looking at your proposed reformation, you're no longer around, the bank has been acquired by somebody else, it's a trustee in Ohio or someplace. Why would the trustee believe that the trustee is precluded from giving to high school students who are graduating from non-governmental high schools, in other words, private schools?
Why would he believe he couldn't?
Yeah.
Well, I think that because the trust provides, it talks about.
I thought you wanted to give to any high school. You're talking. Do you want public high
Any
schools?
public high school.
Well, it's the 1988 amendment, I think, references.
No, but I'm talking about
Public schools.
your proposed amendment.
No.
Well, my propose is broader.
Yeah, I know.
You want private schools, in theory?
Well,
I don't even know if there are any private schools, but I want to make sure that whatever we do here, it's not going to private schools, which seems to be, not because I have any personal bias one way or the other, because I'm trying to figure out what the testator wanted. And the testator selected a public high school.
Well, then I will say, my response would be that the Reformation should in fact be directed to the donor's intent, and the donor was clear, both as reformed over the years, that it was to be public high schools.
Okay, now my second question, which is, I admit that there may be more public high schools than existed because the population has increased and they've split up, but I went to, I'll take, the town of Newton. I went to Newton North. We really can't stand Newton South. Not one dime of my money is going to Newton South. Now, Newton North has been combined with something else, and you're now saying just to any public high school. What is the problem if we keep it at least to whatever that original school was? Or does it no longer? I know it became Plymouth Carver.
Now it's. I think Plymouth North would now be the successor high school if you follow the sequence, as opposed to Plymouth South.
And if you can give whatever the full amount of money is to one student.
Why couldn't it be Plymouth North?
Yeah.
Well, I guess it would depend on how you interpret the donor's intent as gleaned from the document itself. And I think a fair reading is that in 1950, when there was one high school in the town of Plymouth, I see nothing that would prevent that from being narrowed in any way.
So there was is it clear from the record there was only one high school at the time?
Mm-hmm.
There was only one high school, and it merged, I think, in 1959 with the town of Carver.
So one way to read it is that he was making the scholarship available to every child, every student who graduated from a public high school
in the town of
Plymouth.
In the town of Plymouth.
Thank you, Mr. Durland.
Thank you.